Government Business Order of the Day number 3, standing in the name of Mr Edgington, the Housing Amendment Bill 2026, Serial 55, to move the bill be now read a second time.
Minister.
Madam Speaker, I move the bill be now read a second time.
The question is that the bill be now read a second time. I call the next speaker to this debate. Member for Gwadja.
Thank you, Madam Speaker. Madam Speaker, I rise today in opposition to the CLP's proposed amendments to the Housing Act 1982. Territory Labor want to make it clear we oppose this amendment. We oppose this amendment substance on principle. The bill seeks to remove any obligation on the Minister to afford procedural fairness to remote housing tenants when making rent determinations. This is not a minor amendment. It is not just a technical clarification as we were told it was. It is a significant and deliberate shift in how government makes decisions for some of the most vulnerable Territorians. The CLP claim this amendment is necessary in response to the High Court decision. That claim does not withstand scrutiny. The only proposal from the CLP today to address remote rent tenancy issues is to remove their right to be heard. The High Court did not rule that Parliament should strip tenants of their right to be heard. The Court did not instruct the government to abandon procedural fairness. The Court did not say tenants should be silenced. In fact, the ruling was the exact opposite of this. It was a ruling that tenants had not been properly heard as required by law. So rather than address what was effectively a breach of law, the CLP government has chosen to completely strip procedural fairness out of the legislation. This is a government that proves time and time again that listening to Territorians, hearing them, acting with integrity on issues which concern some of the most vulnerable members of society is of no interest to them. The High Court decision handed down on the 3rd of December 2025 ruled that the rights of remote housing tenants had been adversely affected by the lack of procedural fairness. Madam Speaker, rather than fixing the procedural fairness shortfalls identified by the High Court, this government has chosen the most extreme response available, legislating to silence tenants altogether. The proposed amendment explicitly states that the Minister is not required to give affected persons an opportunity to be heard. That is not reform, that is avoidance. That is a deliberate rejection of fairness. Procedural fairness exists for a reason. It ensures that decisions affecting people's lives are made transparently, rationally, and with accountability. It requires decision makers to listen before they act, particularly when those decisions involve people's homes, finances, and stability. This bill does the opposite. Madam Speaker, the government has sought to justify this amendment by pointing to urgency. That argument does not hold. The suggestion that procedural fairness prevents timely decision-making is simply not supported by the legislation as it stands. The CLP have had every opportunity and power to consult with remote housing tenants about what framework works best for them. The CLP could have taken the time to hear, Madam Speaker, from remote housing tenants about the individualised and tailored rent models without rushing through changes on urgency. Urgency does not require silence, and good governance does not require making decisions without hearing the concerns of territory stakeholders. Good governance should not come from and should not come at the expertise of excluding the very constituents the government is meant to represent. Madam Speaker, I'd like to take the opportunity to put on record those stakeholders' concerns. Madam Speaker, I seek leave to table the document.
The question is leave granted? Those in favour say aye, to the contrary no. I think the ayes have it. Leave is granted.
Thank you, Madam Speaker. Madam Speaker, the document has been issued by the Northern Territory Aboriginal Housing Northern Territory. The peak body released a statement strongly raising their opposition to this hastily law reform. They said, "We reassert our unequivocal rejection that any untested remote rent model that unfairly, disproportionately affects remote Aboriginal tenants across the Territory." In fact, they called for the CLP to meet with AHANT, Aboriginal Housing Northern Territory, and the 4 land councils, legal and remote housing experts and other important stakeholders to work through the significant issues that are attributed to the previous remote rent framework and avoid repeated same mistakes of the past. The CLP are not taking this opportunity to learn from mistakes. They are repeating them. The previous Labor government absolutely acknowledged that mistakes were made in how the remote rent framework was implemented. Those decisions were taken with the intention of creating consistency and sustainability, but processes failed tenants. Acknowledging that failure means, Madam Speaker, that it is not acceptable. It is responding to that failure by permanently removing the safeguard the High Court identified as essential. Madam Speaker, we're talking about self-determination principles. This amendment contradicts them. The CLP haven't considered all the options to respond well to the High Court's decision. Not only does this amendment not reflect the High Court decision at its core, it is also a significant legislative change that prevents future obligations to consult with remote renters, Madam Speaker. This is a huge shift. Yet here we are, Madam Speaker. There has been no meaningful conversation with the housing sector, no engagement with legal experts, no attempt to hear from tenants themselves. At best, Madam Speaker, this government's idea of consultation is a single letter to remote renters advising them that their rent will continue as is. Madam Speaker, this decision will keep rents at the same unaffordable levels as the previous model. It will only push more families into financial distress. What we are seeing across the Territory is increasing poverty levels at some of the highest cost of living nationally. High numbers of rough sleepers and people experiencing homelessness. Removing the obligation to consult with the very people this legislation affects is condemning remote Territorians, some of our most vulnerable Territorians, to untenable disadvantage. Madam Speaker, if the government's stated intent is to address remote housing, then consultation is not optional, it is essential. It is through our consultation that we understand what is fair. We understand what fair rent setting looks like in remote context. It is through listening that we can take account of hardship, cultural obligations, overcrowding, and income insecurity. And it is precisely those perspectives that the High Court identified are missing, Madam Speaker. Instead of addressing that failure, the CLP has chosen to entrench in its legislation. The correct response is to fix the process, not to legislate around it. This amendment gives the power to the Minister to make rent determinations without notice, without consultation, without explanation, or without accountability. This strips away the rights from remote tenants. It strips away their right to have a voice. That should concern every member of this House. It is this legislation that flies in the face of international law. Madam Speaker, remote public housing tenants are overwhelmingly Aboriginal Territorians. The CLP have repeatedly shown a dismissive and punitive approach to public housing tenants, particularly in remote communities. Removing procedural fairness empowers government that has already shown its willingness to punch down on Aboriginal Territorians. That is why procedural fairness exists. It's not there for convenience. It's there to hear Territorians, to respect them. But, Madam Speaker, what does the Territory get with a CLP government? less transparency in rent setting, no opportunity to explain hardship or personal circumstances, no protection against blunt, one-size-fits-all determinations, Madam Speaker. These are not abstract risks. They are foreseeable and real. Procedural fairness is not a technical inconvenience. It is a cornerstone of administrative law and democratic governance. When governments lose in court, the answer is not to remove the rule they failed to follow. The answer is to do better. Territory Labor will not support legislation that entrenches unfairness, concentrates power and silences the most vulnerable people. Madam Speaker, this legislation silences those most affected by government decisions. For those reasons, we will not support this bill. We will oppose this bill, Madam Speaker. As I've said, instead of fixing the mistakes, Madam Speaker, accepting a different interpretation and giving tenants a basic procedural fairness, the CLP is changing the law to get around it. The Housing Minister wants to have the power to approve rent hikes without tenants being heard, rather than admitting that the government and the department need to change the processes. The CLP is deleting procedural fairness so they don't have to follow it. Thank you, Madam Speaker.
Deputy Chief Minister.
Thank you, Madam Speaker, and I rise to make a contribution today, Madam Speaker. But before I do, I just want to inform the House, we are fixing a Labor mistake, Madam Speaker. We are fixing an issue by the previous Labor government, in fact by the Leader of the Opposition, Madam Speaker. This is their mistake and we're fixing it. And yet the member for Gorges stands up and says
Okay, silence,
NT
please.
people aren't properly heard and a lack of procedural fairness. The CLP had every opportunity to hear from tenants, Madam Speaker. But what he didn't say, Madam Speaker, is that the previous Labor government took this to 3 levels of court. They took it to NTCAT, to the Supreme Court and then to the Appeal Court. So when he's over there saying, oh, we're not properly heard, they had the opportunity to fix it. What did they do? They took it to court, Madam Speaker. They had the opportunity to go out there and speak to these people, but they didn't. They took them to court. How shameful is that? Unbelievable. And yet he goes over here and rants in his high moral ground how these people haven't been heard and lack of procedural fairness, every opportunity. They took them to court.
Please pause, Minister. What's your point of order, member for Guancha?
Standing Order 20, I'm actually really genuine in hearing what the Deputy Chief Minister has to say. The member for Goyder keeps interjecting. I think he's going to have an aneurysm if he keeps going.
Take your seat. Any member that tries to disrupt another member's speech through a point of order which is not actually a point of order will be warned. Please
thank you, Madam Speaker. So let's just go back a step here. This started in 2023 under the previous Labor government, where they made a determination they didn't follow the rules. They didn't give the remote framework the procedural fairness. And we know that the member for Gorges gone there and had his big moral high ground about not properly heard and we could have done these things. I want to be extremely clear here, Madam Speaker. This opportunity was there when the previous Labor government in power, they had the opportunity to do it and they didn't. In fact, Madam Speaker, they went to NTCAT, then they went to the Supreme Court and then to the NT Court of Appeal. So for the member for Goyder to go over there and rant and rave and say, acknowledge the failure and go out and hear, they had the opportunity to do this. They didn't. Instead, they took them to court. So it's really a bit hypocritical, Madam Speaker, when the member for Goyder goes over there and rants and raves about this, when the truth is, Madam Speaker, when you really dig down and go through the timeline here, Madam Speaker, the previous Labor government had the opportunity to do exactly what the member for Goyder just spoke about, to go out, to go and talk, go and listen and give that procedural fairness, Madam Speaker, and guess what they did? They took them to NTCAT, they took it to the Supreme Court, then took it to the Court of Appeal. So this amendment, Madam Speaker, is clearly and here today to fixing a Labor mistake. And in fact, I think one thing I do agree with what the member for Goyder just said, mistakes were made by Labor. They're his words, Madam Speaker. They acknowledged that failure. So that's one thing I do agree on, Madam Speaker. This is a mistake made by Labor in 2023. They had the opportunity to fix it. They didn't. They didn't go out and do the procedural fairness. They knew this was on foot, Madam Speaker. And how can I prove that? They took it to court. They started proceedings in the NT-CAT, in the NT Supreme Court, and then all the way into the NT Appeal Court. So for the member for Gorgia to go there and say, this is a heavy-handed approach and had every opportunity to hear from tenants, but he's not really truthful, Madam Speaker. He hasn't really laid out the timeline exactly where all this goes. Again, we are fixing a Labor mistake, Madam Speaker. That's what we're doing here today, Madam Speaker. What we're trying to do here is to mitigate any damages and fix the mistake, and then we can go back and look at this, Madam Speaker, to work out how can we make sure that the Territory is in the best place moving forward. So this is really about fixing the legislation, fixing the mistake made by the Leader of the Opposition. The Leader of the Opposition hasn't spoken yet, and I'm sure this is an opportunity for her to go up today and explain to Territorian why she made the mistake, why she took this to court, not on one occasion, not on two occasions, on 3 occasions, Madam Speaker, and then it was off to the High Court where they lost that case, Madam Speaker, and we're here dealing with the ramifications, fixing the mistake made by Labor, fixing when they had the opportunity to go out and let the tenants be properly heard, using the member for Gorgia's words. They didn't do that, Madam Speaker. So I just want to be very clear to Territorians and people listening today, we are here today fixing a mistake which has been acknowledged by the member for Gorgia. Mistakes were made by Labor. Fix the process, not the legislation around it. They had the opportunity to do that when they were in power. So it's just absolutely astounds me that the member for Gorgia can go and talk about that and say that and not just collapsing ground. He should be so embarrassed about making those words because he had his opportunity. He didn't. He took it to court on 3 occasions, Madam Speaker. I just hate to see what the legal fees would be for those 3 occasions, Madam Speaker. Again, another waste of taxpayers' money. Thank you to the previous Labor government, thank you to the Leader of the Opposition and the member for Gorgia, who would have been the Attorney-General at that time. So it's really embarrassing for them, Madam Speaker, but we're here today to lay out the timeline. We are fixing their mistake. We're doing it in a way in the best interest of Territorians, in the best interest of all Territorians, Madam Speaker, and I commend the bill to the House.
Madam Speaker.
Member for Gorgia.
Thank you. I wanted to respect your ruling and not interject on the Deputy Chief Minister, but I'd ask
No, sorry, just pause there. If you don't have a point of order, you've already spoken in
point
this
of order
debate.
31.
You don't get a second jump.
Well, standing order number 1 then, Madam Speaker.
No, look, sit down,
No,
please.
I want you to retract that.
Sit down. This is not a supermarket. You don't come into Parliament and come up with a point of order that might suit the occasion as the seconds roll by. We don't interrupt debate. You don't get a second bite at the cherry. Are there any other speakers? If you keep this up, you are invited to leave the chamber very soon. Member for Johnston, you've got the call. Opposition Leader. Look, and can I just say at this point, everyone who speaks in this debate will be heard in silence. No interjections, like you were interjecting earlier when the Deputy Chief Minister was speaking. Let's be respectful and use the points of order and the rules of this chamber appropriately. Please continue, Opposition Leader.
Thank you, Madam Speaker. Mine was Standing Order 31. I believe the member for Gorgia was raising an offence from the member for Nelson, who called him a liar and was going to ask him to withdraw that, wanting to respect your ruling to not interrupt debate.
Okay,
we're
take
not allowed
your
to raise
seat,
standing
please.
orders.
The Deputy Opposition Leader did not call the member for Gorgia a liar. It was phrased very differently, which I accept. Are there any speakers? No speakers? Member for Mulca. You've got the call, Member for Mulca.
Yeah. Thank you. Madam Speaker, I rise to speak on the housing amendment legislation. I'd like to start by acknowledging that the government is in a situation where they say they must respond quickly to the High Court ruling that makes the current remote housing rental framework unlawful. I also acknowledge that this was not a problem created by this government, but they are the ones who must fix the problem. And this this solution rather, that they are bringing to the chamber today goes too far. I believe that there must be, say that again, I believe that there must have been many options before the government, but this was not the right option to fix the problem. One option would have been to enact a procedural fairness in relation to the 2023 changes to the rent by going to remote communities and meeting with tenants at community meetings and hearing from them about problems with the rental frame. Another option would have been to return the previous system. Madam Speaker, Mr. Deputy Speaker, I believe someone has been a serious error. I believe someone made a serious error in government and in the department, and people should be called to account for these errors. When the 2003 changes were announced, there was opposition to the recent changes, and many people experienced significant rent increases that may not have been manageable. The High Court made their ruling because the department had failed to go and do proper consultation on this change. What I spoke about yesterday in the chamber is that we must be involved in the decision-making that affects our lives. It's our lives it affects. I am pleased that the Minister is stating that there will be a new framework, and there is intention to consult, but the safeguard of procedural fairness should not be removed from the legislation. What must happen is procedural fairness, not its removal. The department said that procedural fairness was never meant to be part of the Act. But as I understand, the principle of procedural fairness almost always applies to government decisions because it is a safeguard that protects Territorians and the way in which decisions are made about our lives. It is unusual to specifically remove procedural fairness in this way. Mr. Deputy Speaker, I want to talk a bit about housing because there are concerns in my communities about many aspects that require shared decision-making on the ground. We are concerned about design of houses, about the new subdivision for houses. We are concerned about where houses are being built. We are not being included so that we can properly make a decision about housing. When we talk about $4 billion for houses, we want to make sure that we are creating the best possible outcomes and not more problems. If government keep building houses in hub towns, we will see more and more problems. If we continue to build new suburbs and then mix clans within a new sub instead of having camps where one clan all live in that one location, we will see more and more problems. If we continue to build hot bizarre block houses with poor designs, we will see more problems. If the government wants to use the funding in the best possible way, they must come and talk to each community and create a whole housing design based on shared decision-making. We know what is right for our communities, and governments are failing us. What I am saying is that everything must be based on this principle of procedural fairness. Whether it is housing design, or setting a new rental frame, the government must do the job working with the people. This is poor legislation. It is lazy legislation. And I do not believe this was what the High Court intended for the people of the Northern Territory. Thank you, Mr. Deputy Speaker.
Thank you, Member for Mulca. Member for Namatjira.
Thank you, Mr. Deputy Speaker. And Mr. Deputy Speaker, I want to remind the House of why we're standing here debating this piece of legislation and these amendments today. We're here doing this today because the former Labor government got it wrong. They failed to do the necessary work to consult with people in the bush about the rental framework, I think we raised these issues when we were in opposition, when we were debating this legislation back in 2023. But now we're here having to fix Labor's mess. And I find it pretty ironic and pretty rich that they actually oppose these amendments. Because as I said, we're here today dealing with this because they got it wrong and didn't do the work that they were supposed to. And they say the CLP could have taken the time to listen. Well, I ask you, Mr Deputy Speaker, where were Labor when they introduced this legislation? Did they take the time to listen? Obviously not. Otherwise, as the Deputy Leader had said, we wouldn't have ended up going through 3 courts and be here in this position today. I said, I find it very, very rich, Mr Deputy Speaker, for the opposition to come out the way they have. Now, I want to clear up a few things while we're talking about this legislation, and I really appreciate the input and the contribution from the member for Mulga, and I'm going to talk a little bit about some of that later in my contribution. But specifically, when the document was tabled from Aboriginal Housing NT saying that the rental framework was too high and it is disadvantaging Aboriginal people out in communities. Labor did this, Mr Deputy Speaker. We didn't do it. We're fixing the mess. So in fact, that document condemns the Territory Labor Party for the legislation that they introduced in 2023. We're here trying to fix it, Mr Deputy Speaker, trying to fix the mess that was left behind. And it's funny, Mr Deputy Speaker, it seems to be, ever since we got into government, all we're running around doing, and I know I'm certainly doing it, is running around trying to fix messes left by the previous government. It's like you open a door, you see it in the movies, and all this garbage falls out from behind the door, and all of a sudden you're left there cleaning up the mess. Every time I open a door, Mr Deputy Speaker, that seems to be what I find. And this legislation is a prime example of that, Mr Deputy Speaker. So here we are today, we're fixing it. But we've been put in a position by the previous government that we are on strict timelines and deadlines to have to fix this piece of legislation because, as the member for Mulga rightly pointed out, from that decision from the appeals court, the remote rental framework is unlawful. And it's unlawful because the previous government didn't get it right and didn't do the work, and the appeals court has effectively stated that. And that's put us in a position and a timeline that now requires us to do the work to make that piece of legislation lawful. And we have to do that. And we've been put in this position by the previous government. But as I said, the argument put forward by the opposition is that we're pushing families into financial distress. We didn't do the financial distress, Mr Deputy Speaker. Labor pushed them into financial distress. And if those on the other side were absolutely serious about the remote framework, the remote rental framework, and the people in the bush, we have 4 members over there that represent bush electorates. Where were they at the time, Mr Deputy Speaker, if they thought this piece of legislation, this framework, was so miserable like they're saying today? Why didn't they oppose it at the time? Why weren't they in their cabinet room? Why weren't they in there lobbying their members? And some of them were ministers at the time, Mr Deputy Speaker, and one of them was the minister responsible for this. Why weren't they opposing it? If this is such rubbish legislation, such a rubbish framework, as has been stated today, why weren't they there opposing it? All of a sudden it's our fault. It's the CLP's fault, the big bad CLP. We're putting families in distress for a piece of legislation and a framework that was introduced by the previous Labor government. I notice the grins and the smirks from over there. You can grin and smirk all you like, but the reality is this is your framework. Your framework. You introduced it, so everything you're saying here today, trying to blame the CLP for, was of your doing. And again, I can't believe that they're up here condemning the CLP for their decision, their rental framework, the framework that they introduced. But fixing this immediate legal matter from the High Court, because it was ruled unlawful, as I have stated, Mr Deputy Speaker, has put some specific timelines that we must meet because it's been deemed unlawful. Now, there's lots of things we'd love to be able to go and do, and the member for Malka was quite right, and he raised some valid points about the framework and about that consultation and doing a review and everything else. The sad part about this, Mr Deputy Speaker, these are all things that we'd love to do, but because of the timelines pushed on us, because the previous Labor government failed in this framework, we can't do those things. We have an immediate issue that we need to rectify right now, right here today. Because if we don't rectify that matter, then we will fall afoul of the appeals court. But what are we going to do, Madam Speaker? We're going to make sure that we actually get it right, unlike the previous Labor government who seems not to have been able to do that. So we have to fix the immediate problem because of the decision that makes the remote rental framework unlawful. Again, we didn't make it unlawful, the previous government made it unlawful, and we're here fixing it. But we're going to do the right thing, Madam Speaker. We will be doing a review of the remote rental framework. We can't do that straight away, we can't do it right now, we can't do it before we have to amend this legislation to make the remote rental framework lawful. Otherwise, as I've said, we fall afoul of the court. We have to get this in straight away. So we will make these amendments to the legislation to make the remote rental framework lawful, again, because the previous Labor government brought in a piece of legislation, a framework that has been deemed unlawful. But we will go away and we will do the hard work, Madam Speaker. We will go away and we will look at the remote rental framework to make sure that it is fit for purpose, that we're not disadvantaging people out in the bush. That is the work that we will do into the future, and we give that commitment that we will do it, Madam Speaker. Because Labor obviously didn't do the work in the first instance. They had the opportunity, they had all the time in the world to do this, but they put in a framework that has been clearly shown now by the courts to be unlawful. And they still have the gall to stand up in this chamber and blame the CLP for their framework and their failures. It's like history is a foreign place to them, Madam Speaker. The things that happened 2 years ago, no, don't worry about that. That didn't really happen. It's a foreign place. They just will not admit to their mistakes. I would love to hear the members of the opposition actually stand up today and say, yes, we got it wrong. We should have fought harder for the people in the bush because we don't think this framework was right. But I'd love to hear them stand up and say that, because then they'll show to the people that they represent that they did have their best interests at mind, rather than standing up here today and slinging mud at the CLP because we have to fix their problem. But as I said, Madam Speaker, we'll go away and we'll do the work. We need to do the work. It's the right thing to do, and we'll do it. We'll go away and review that framework and make sure that it is fit for purpose. But yes, Member for Malka, I listen to your contribution, and I always do, because there's a lot of wisdom comes from the Member for Malka. And all the points that you raised were considered, and we would have dearly liked to be able to do those. But the time frames and constraints put on us by the court unfortunately don't allow us to do those things. It would take too long. Just to make some of the changes that the Member for Malka raised, whilst sounding simple, actually take a little bit of time, and that would probably make us fall afoul of the court's decision. But, Madam Speaker, I look forward to possible contributions from the opposition. I said I'd love to hear them actually stand up and take responsibility for the errors that they've made, and then apologise to those people who have been disadvantaged by their framework. Remember, Madam Speaker, this is not our framework. We're fixing the mess left behind to us from Labor. It was their framework. So yes, we have to make these amendments, and we will. We'll make the framework for the period lawful going forward, and then we will go away and do the necessary work to make sure that we get that framework right. Because, yes, unlike the opposition, we'll do the work properly. We'll make sure that the people in our remote communities have a rental framework that works for them and they're not disadvantaged, or, as the opposition have said, put in a place where they're put into financial distress. Well, they're put into financial distress by their own members, Madam Speaker. I welcome the opportunity to stand up and speak about this matter and correct the record and put things on the record that are actual fact, rather than trying to rewrite history and deny that someone had any part in a process which has absolutely been deemed unlawful by the courts. Thank you, Madam Speaker.
Thank you. Look, just at this moment, I'd like to provide some clarification on this old chestnut that comes up fairly regularly in Parliament around allegations of lying. It happened yesterday and it's happened again today. It is not in order to accuse another member of lying or to call them a liar. It is not in order to impute deliberate dishonesty, even in passing by an interjection. Yesterday, we heard one member infer that or question whether someone had misled Parliament. I allowed that. And today, another member questioned whether or not another member had lied. This is shaky ground, particularly when you use the word liar or lying. I allowed that comment earlier to go through to the keeper because it wasn't actually an allegation, it was a question similar to yesterday. Is the member misleading Parliament? Is the member lying? But it is much preferable that the word liar or lying is not used. If someone is actually accused of being a liar, that is absolutely unacceptable. But I would warn both sides of this chamber that this is not parliamentary. If you want to accuse someone of misleading Parliament formally or lying formally, you do it through a substantive motion. Are there any other speakers? If there are no other speakers, Minister in closing. Oh, sorry, Member for Johnston.
Madam Speaker, I rise today to speak to the Housing Amendment Bill 2026. Madam Speaker, we're told that this is a matter of urgency, and I note that this is the 12th bill brought on urgency in this parliamentary term. And as I've said many times in this chamber before, emergency powers are for use during extraordinary, unpredictable and urgent crises such as wars, natural disasters, pandemics, terrorism, civil unrest. And today, once again, it's being used to push through a law and avoid scrutiny and stop us doing our jobs properly. So what is the emergency? The bill's a reaction to a High Court decision, as we've heard, from December 2025, a challenge that's been working its way through the courts since 2022. The government's had a long time to develop an appropriate response, to consult with tenants, and instead we're presented with a last-minute fix that seeks to bypass the very concept of fairness. Madam Speaker, moving a bill on urgency, and fellow members in this chamber, government, moving a bill on urgency stops your fellow elected representatives from properly analysing a bill. It stops us from seeking legal and policy advice on a bill. It stops us from consulting our communities on the bill, stops us from consulting experts and peak bodies, stops us from proposing amendments. Madam Speaker, it prevents us from making the bill better, it prevents us from participating in the law-making process, and it undermines democracy. Now, as the member for Mulka said, this is not a problem created by this government, and I agree it's a problem that needs fixing. But when we asked in our 20-minute briefing what options had been considered to fix this problem, we were not given an answer. When we asked who was consulted in the development of this bill, we were told no one. This bill makes one change. It inserts the following. Under 3A, in making a determination under this section, the Minister is not required to afford any person who would be affected by the determination an opportunity to be heard in relation to the determination. So, to fix the issue, the response has been to deny procedural fairness for public housing tenants. Madam Speaker, rather than amend the legislation to require that the Minister consult with affected persons, the CLP government has chosen instead to remove the right of affected persons to challenge a decision by the Minister in regard to determining rent. The Northern Territory's 4 land councils and 𝐅𝐔𝐋𝐋, the Central Land Council, Northern and Tiwi land councils, have united with 𝐼𝐺A and Aboriginal Housing NT together against what they describe as the government's latest attack on Territorians' basic rights. In a joint statement, these 6 organisations remind us that, and I quote, "Procedural fairness is a safeguard that protects every Territorian. It's about making sure government decisions that affect people's lives are made properly and fairly. It's a legal protection built into government decision-making to make sure that there is a minimum level of fairness in government decisions." By removing these requirements, the government is making a startling admission. As 𝐼𝐺A's Chief Executive Ben Grimes stated, this is an admission of failure. It suggests the government does not believe it is capable of making decisions in a fair way, so it is introducing legislation to allow it to make decisions in a way it knows will be unfair. The government claims this amendment is required by the High Court's decision, but this is a false excuse. Legally and practically, this amendment is not required. All that is required is that the government speak with tenants on decisions which directly affect them. Instead, the government is using the decision as an excuse to abolish procedural fairness completely, a move described by stakeholders as a dangerous move and a slippery slope. Madam Speaker, we must be honest about who this affects. We heard this from the member for 𝐼𝐺A earlier. This legislation almost exclusively affects Aboriginal Territorians, particularly those in remote communities. Northern Land Council Chairperson Matthew Ryan has been clear when he said, and I quote, "This is racist legislation. Our people should have the same rights as all Territorians." This bill also undermines our closing the gap commitments to shared decision-making, which this chamber passed a motion supporting yesterday. Leanne Caton, CEO of Aboriginal Housing NT, has noted that despite being the peak body for Aboriginal community housing, they, and I quote, "have not been consulted in any way in relation to the amendment of the Housing Act." This is despite being members of the Joint Steering Committee, where they are supposed to be genuine and equal partners. Madam Speaker, for reform to be meaningful, the government must work with tenants to address systemic issues, implementing income-based rent, reducing overcrowding and addressing the rising cost of living. Instead, we're rushing through a law that risks further litigation at a significant cost to the taxpayer. This process either reflects an inability by government to plan for predictable legal outcomes or another excuse to avoid democratic accountability. Madam Speaker, I cannot support a bill that views the fundamental right to be heard as an administrative inconvenience. I cannot support a bill that replaces fundamental justice with legislated unfairness. Thank you, Madam Speaker.
Member for Blaine.
Madam Speaker, I rise. The technical aspects our ministers have covered quite well. I just want to bring a bit of history to this matter. So, the relevant determination was made on the 23rd of December 2021 by the Minister for Housing, who was also the Minister for Territory, Families and Urban Housing, the member for Sanderson, Kate Warden. At that time, the member for 𝐃𝐄𝐁 was the Minister for Remote Housing. He's had a great contribution this morning, but what we haven't heard is how the member for 𝐃𝐄𝐁 stood up for his constituents, the Indigenous people in remote areas who live in remote housing, what he did to stand up for them, to prevent, he's said that, the rent was put up. The High Court has found that, there were issues with that determination that has impacted our ability to appropriately levy rent. What did the member for 𝐃𝐄𝐁 do to represent his people? Again, unfortunately, this is just another example of this government having to clean up a mess left by the previous Labor government. The list goes on. Previously in this House, I've talked about the calamitous state that our power industry was left in, and the current opposition leader, who was the Minister for Essential Services and Renewable Energy at the time, went in media and spruiked many times how great their plan for 50% renewables by 2030 was, but when journalists requested by Freedom of Information that report, all but 2 pages were blacked out. The front cover and the back cover were unredacted. Every single page in between, Madam Speaker, was blacked out. That was honesty. That was consultation under the former Labor government. That was their view of keeping Territorians informed on the true state of affairs, Madam Speaker. Madam Speaker, the current opposition leader was a member of cabinet at that time. What contribution did she have for her remote constituents when that determination was being made? How did she stand up for her constituents when those rents were being put up? You know, we are constantly being forced to do the best we can in a bad situation that we have inherited from the previous Labor government. So, Madam Speaker, in my time, I've lived in share houses, I've rented. You know, I'd never really got a chance to, you know, tell the landlord what rent I wanted. The rent was the rent. That was the market. The landlord made a determination. They said, this house is $500 a week, $400 a week. That room, your share is $80 a week. That's it. You know, the Housing Act is quite clear. The minister can make determinations from time to time to set the rent. I'm currently going through a process with my constituents right now. The community housing providers in my electorate are reviewing their rents. There's a formula that it's based on, and there's no negotiation in that process. The rent is the rent. They get notice, they prepare, but they can't go back to, you know, the community housing provider and say, sorry, I don't like that rent, I don't want to pay it. That's just what they have to pay. So, Madam Speaker, like so many other things, you know, the 50% renewable target by 2030, I could go on and on about all the messes we have to clean up. This is yet another one that we have to fix up, Madam Speaker. Thank you. Sorry.
Are there any other speakers? Member for Barclay. Oh, Minister, in closing, my word, sorry.
Thank you, Madam Speaker. And in closing, firstly, I do want to thank the members that contributed, the member for 𝐷𝐷𝐿, the member for 𝐷𝐿, the member for Namatjira, the member for Johnston and the member for Blaine. Madam Speaker, I just want to outline a few points, and I think it's important to understand how we got to this point. If we look at some of the history in regard to this particular matter, I think if we look at, it's clear that this is a matter that the reason we're here today is because of decisions that Labor made during their term of government. Madam Speaker, this bill amends the Housing Act to ensure it can operate in the future as intended and will allow for government to effectively set rent for public housing. We are responding to a High Court decision. These amendments do not do any more than ensure the remote rent framework operates in a way that was always intended. I acknowledge that the former government, we know they've made a real mess of the remote rental framework. We know that the opposition leader was part of that government. We know that the member for 𝐷𝐷𝐿 was part of that government that made an absolute mess of the remote rental framework. And that's why, Madam Speaker, once this legislation passes, I've asked the department to undertake a complete review and redesign of the rental framework that's being applied today. All this legislation does, as I said, it confirms the current remote rental framework so that we can move forward, engage, consult work with Aboriginal people, including members of the Joint Steering Committee, which is Aboriginal Housing NT, the land councils, so that we can work together to get a framework in place that's going to be suitable for Aboriginal people living in remote areas. This is what Labor made a complete mess of. I just want to say there were no provisions in the framework that required the government to consult with more than 5,000 remote tenants on an individual basis. The High Court decision found that in the absence of express words making clear that a condition to afford procedural fairness was not required, it would be implied, contrary to the original design and implementation. The former government, when it designed and implemented the remote rental framework, did not intend to consult on an individual basis with any person. So let's make that very clear. The government, the former Labor government, had no intention. They expressed that intention by putting in place determinations around the remote rental framework without engaging with Aboriginal people. So to come in here today and put a case forward from the member for Guaja that all of these things should or shouldn't have happened is clearly not the case. This bill focuses on the regulatory operation of the determination of rents payable within the remote public housing sector of the Northern Territory. These amendments are intended to address deficiencies identified through the litigation proceedings in the decision of the High Court of Australia in Badari versus Minister for Territory Families and Urban Housing 2025, High Court of Australia 47. They will improve regulation and administration of public housing in the Northern Territory through the following amendments. After section 23, paragraph 3, a new section 3, capital A, is being inserted, which provides that in making a determination under this section, the Minister is not required to afford any person who would be affected by the determination an opportunity to be heard in regard to that determination. Madam Speaker, the remote public housing sector, for the remote public housing sector, these changes are important and necessary to ensure the setting of remote rents into the future. There's a couple of points that I would like to make, Madam Speaker. Procedural fairness was never in the Act. So I've heard some members suggest that we're removing procedural fairness. We're not removing procedural fairness. Procedural fairness was not written into the legislation. So let's be very clear on that. Tenants will not be adversely affected. Their rents will remain the same as is. What this legislation is doing is confirming the current arrangements so that we're in a position to move forward and engage with Aboriginal people right across the Northern Territory. The hardship provisions and safety net remain. There's no changes to the hardship provisions, and the safety net remains. Excuse me. So essentially, Madam Speaker, we're here today sorting out the former Labor government's mess that they left us in when we came to government. We've heard today, and I think it was the member for Nelson pointed out that every step along the way, the former government challenged court proceedings. The High Court made their decision last year, and today, acting on urgency, we're here to set the current rental framework in place. Now, there's been a long line of history when it comes to lack of engagement with Aboriginal people in setting this remote rental framework together. We know that when Labor was out talking about the remote rental framework back in years ago. We know that there was complaints. We know that, in fact, in my electorate alone, Madam Speaker, there was a number of complaints raised with me at the time that there was insufficient consultation with Aboriginal people living in remote areas. This is the rental framework that the Labor government put together, which has impacted on Aboriginal people in the Northern Territory. I want to make it very clear that moving forward, once the legislation is passed, our job is to get out and engage, work with Aboriginal people to ensure that we have a suitable framework moving forward. And I think these are the issues that are clearly Labor don't want to talk about because they know the reasons we're here today. And yes, they can send messages out that we've apparently somewhere along the line the CLP has done this or not done that or have had time to do this and they've done it wrong. We're here to fix a Labor mess. There's no ifs, buts, maybes of how we got here today. We're here to try and fix Labor's mess and confirm the rental framework so that there's a continuity of rent being paid. Nobody is being affected by this decision. In fact, all it's doing is confirming the current rental framework. Madam Speaker, in light of the High Court's decision, the Department will also be running a process to calculate the rent that tenants were liable to pay since the implementation of the remote rental framework and will repay amounts it has collected which exceed that liability. So those two processes that we're putting in place, Madam Speaker, once this legislation is confirmed, we will be ensuring that we'll be repaying any amounts that have been collected which have exceeded the rent that should have been collected. Madam Speaker, in regard to this legislation, nothing changes for the remote rental framework. All it's doing is confirming where we are today, and I commend the bill to the House.
The question is the bill be now read a second time. Those of that opinion say aye. To the contrary, no. Aye. I think the ayes have it. The clerk.
A bill for an act to amend the Housing Act 1982.
Minister.
Madam Speaker, I move...
Third reading.
I seek leave to move the third reading.
Is leave granted?
Aye.
No. Leave is not granted. We will move into consideration of detail stage.
Order. The Assembly will consider the Housing Amendment Bill 2026, Serial 55. Do anyone want to indicate any of the 5 clauses they wish to particularly talk about?
3A.
3. Any other clauses people wish to do? No. Okay. Is it the wish of the Assembly that clauses 1 to 2 be considered together? There being no objection, it is so ordered. The The question is that clauses 1 to 2 stand as printed. Those of that opinion say aye, to the contrary no. I think the ayes have it. The question is that clause 3 stand as printed.
No.
Member for Johnson.
Thank you. Minister, what other alternative solutions other than the new 3A were considered?
Thank you, Member for Johnson. Yes, we considered a number of options. One was to revert back to try and revert back to the old previous system. One of the other options was to try and implement a zero-based, a zero rent framework decision by the Minister. But there's a number of issues. The High Court decision was made last year, which required us to act and act quickly. All of those options would take quite a substantial amount of time and resources to implement. This is the most effective way to deal with the High Court decision as it stands.
Thank you, Minister. And who was consulted in identifying that this was the most effective?
As legal advice in regard to the High Court decision is that we need to act and act quickly to implement the decision. What I have said is that once that decision is made, our intention has always been to go out, engage with Aboriginal people and establish a rental framework moving forward with the Aboriginal Housing NT and the land councils to ensure that we have a framework in place which meets the needs of all players moving forward. This legislation is to make an urgent decision based on the High Court decision so that we can move forward.
Thank you. Minister, under Clause 3A, could the Department of Housing decide to change the rental framework again without consulting tenants?
Point of order. 155, Ron, if we're talking about the clause, I think the member for Johnson's going on and talking about things that may have a hypothetical. This should be confined to how the clause works, and that's not irrelevant.
Look, I'll let the Minister make a judgment as to whether I don't think it's acceptable.
Member for Johnson, yes, these amendments will effectively allow me as the Minister to make a determination, a legal determination moving forward so that we can confirm the rental framework. The importance of that is having that continuity of paying rent with the intention that we set a new rental framework, which is going to require quite substantial engagement and consultation. That's the aim of this, is to confirm the current arrangements so that we can move forward and engage with Aboriginal people to establish a new framework.
Thank you. So under this clause, could a policy change to how rental debts are collected under the Act be made without consultation with tenants?
They're matters of policy. They're not reflective of this clause. So.
And similarly, which may be the same answer, under this clause, could the Department of Housing raise rents to unpayable levels to effectively force the eviction of tenants without any consultation?
Yeah, as the Minister would, as previous ministers have done, it would allow the Minister to make a determination and set those rents that are payable. And of course, in doing that, we want to ensure that those rents are consistent with what they've previously been.
But so the answer is yes. Those decisions could be made without consultation with tenants. Am I understanding correctly?
Those decisions have been made for quite a substantial period of time.
Understood, Minister. Thank you. That's all. I have no further questions.
Leader of the Opposition.
Thank you, Mr Deputy Chair. Minister, with this amendment, will it apply to all public housing tenants?
Yes, Leader of the Opposition, this applies to all rents in the public housing.
Thank you, Minister, and just understanding that response I appreciate. So that means as the process is now amended through the Act, yourself as Minister could declare any type of housing determination for any public housing tenant across the Northern Territory without consultation.
That's always been the case, yes.
Well, it hasn't always been the case, but yeah, so that'll be now.
It has been.
Other question was, beyond setting rent, are there ministerial determinations that this amendment would apply for outside the rent formula or framework?
This just applies to rent setting under the Act.
Thank you. I just need to be clear, and I appreciate that response, because we had some legal concerns that any ministerial determinations that are not rent related could also be made for public housing tenants across the Northern Territory without consultation. So in terms of criteria for tenancy guidelines or tenancy documents, just wanted to be very clear on that so people who are renting in our public housing across the NT are aware that any changes that affect them may not be consulted first. Is that correct, Minister?
This amendment relates to the inclusion of Section 3, capital A, into Section 23, and that relates to rent.
Thank you.
Any further questions? Okay. The question is that Clause 3 stand as printed. Those that opinion say aye, to the contrary no. Aye. I think the ayes have it. Is it the wish of the Assembly that the remainder of the bill be taken together? There being no objection, it is so ordered. The question is that the remainder of the bill stand as printed. Those of that opinion say aye, to the contrary no. Aye. I think the ayes have it. The question is that the bill be agreed to. Those of that opinion say aye, to the contrary no. Aye. I think the ayes have it. Minister.
I move that the bill be now read a third time.
The question is that the bill be now read a third time. Those of that opinion say aye, to the contrary no. 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 Aye. Ayes. I think the ayes have it. Division called. Ring the bells.
The outcome of the division is 17 ayes and 7 noes. The ayes have it. The motion is passed.